Hi, I am Cynthia, your San Antonio real estate consultant. In the last two videos, I covered the first two parts of the buyer representation agreement. Be sure to go to my website if you did not watch one or the other videos that cover the new NAR rules before watching this one. Now this week, I am going to discuss paragraphs 8 through 18 of the buyer representation agreement. Paragraph 8 talks about representation. 8A states that each person signing the agreement represents that the person has a legal capacity and authority to bind the representative party to the agreement. B states that the client is not currently a party to another buyer-tenant representation agreement with another broker. C states that the client represents that all of the information relating to the client's ability to acquire property in the specific market area outlined in the contract is true and correct. D requires information, if applicable, regarding an employer relocation company or other entity that will provide benefits to a client acquiring property. And E states that the broker is not authorized to execute any documentation on behalf of the client concerning the property. Now moving to paragraph 9A, intermediary status, states that the client desires to see the broker's listings. If the client wishes to acquire one of the broker's listings, the client authorizes the broker to act as an intermediary, and the broker will notify the client that the broker will service the parties in accordance with one of three alternatives. Now, I'm not going to go into the whole paragraph, but I will summarize a couple of situations where intermediary status can occur. 1, the seller owner of the property is using an agent from the same brokerage. And 2, the seller owner of the property is serviced by the same associate who is servicing the client, i.e. the buyer wants to purchase one of their agent's listings. So each situation requires specific steps to be taken to ensure both the seller owner and buyer clients are aware intermediary status is present, including written notification. Also, a notice is stated at the bottom of this paragraph, providing additional information. 9B states that the client does not wish to be shown any of the properties that the brokers has. Paragraph 10, competing clients, discusses that the client's broker may represent other prospective buyers or tenants who may be interested in making an offer on the same property. Paragraph 11, confidential information, states during the term of the agreement and even after it ends, confidential information stays confidential except as authorized by the client or required by law. B, unless otherwise agreed or required by law, a seller or the seller's agent is not obligated to keep the existence of an offer or its terms confidential. Now, if a listing agent receives multiple offers, the listing agent is obligated to treat the competing buyers fairly. In this case, the broker will always ask the seller's permission to share this information with the agents that are representing clients that are submitting an offer. Paragraph 12, mediation, discusses that the parties agree to negotiate in good faith in an effort to resolve any dispute that may arise or related to the agreement or any transaction related to or contemplated by the agreement. If the dispute cannot be resolved by negotiation, the parties will submit the dispute to mediation before resorting to arbitration or litigation and will equally share the costs. Now, paragraph 13, default, states that if either party fails to comply with the agreement or makes a false representation in the agreement, the non-complying party is in default. It goes on to discuss what happens if one of the parties are in default. Paragraph 14, attorney's fees. If the client or broker is a prevailing party in any legal proceeding, brought as a result of a dispute under this agreement or any transaction related to this agreement, such party will be entitled to recover from the non-prevailing party all costs of such proceedings and reasonable attorney fees. Paragraph 15, limitation of liability, states that neither broker nor any other broker of their associate is responsible or liable for any person's personal injuries or for any loss or damage to any person's property that is not caused by the broker. The client will hold broker, any other broker, and their associates harmless from any such injuries or losses, and the client will indemnify the broker against any claims for injury or damage that the client may cause to others on their property. Paragraph 16 is the area of the contract where other documents that are a part of the contract are listed. Paragraph 17 is special provisions, and this is where additional clauses can be added to address specific concerns or conditions. Now, examples include financing, repairs, contingencies, and timelines. The selection of special provisions depends on the transaction and the client's needs. Paragraph 18, additional notices, includes A, in accordance with fair housing laws and the National Association of Realtors Code of Ethics, brokers' services must be provided without regard to race, color, religion, national origin, sex, disability, sexual orientation, or gender identity. Local ordinances may provide for additional protected classes as well. For example, creed status as a student, marital status, and so on. B, the broker is not an inspector, an appraiser, a surveyor, an environment assessor, or a compliance inspector. The client should seek experts to render such services in any acquisition. C, if client purchases property, client should have an abstract covering the property examined by an attorney of client selection, or client should be furnished with or obtain a title policy. D, client may purchase a residential service contract. Client should review such service contract or the scope of the coverage. Exclusions and limitations. The purchase of a residential service contract is optional. There are several residential service companies out there operating in Texas. E, when viewing a property, client might be recorded or otherwise monitored without client's knowledge or consent. Additionally, consult an attorney before recording or photographing a property without the owner's knowledge or consent. To reduce risk of wire fraud, the client should refrain from transmitting personal information such as a bank account or other financial information via unsecured email or other electronic communication. If the client receives any request to wire funds, even if the communication appears to come from a legitimate source, the client should verify its authenticity prior to transmitting any funds. Verification should be made in person or via phone call using a recognized phone number not found in the communication. Broker will not send client any electronic communication with instruction to wire funds or to provide personal information. And the final statement on this contract is consult an attorney. It states that the broker cannot give legal advice. This is a legally binding contract. You need to read it carefully. If you do not understand the effect of this agreement, consult your attorney before signing. Yay! We have covered 100% of the buyer representation agreement. Now remember, the main reason we created this video and the others is to make sure you stay educated on this contract to protect you as our agent. Now, let's start the fun part, finding your dream home. I am so looking forward to hearing from you.